Minister has tried to do.
I call the Honourable David Parker.
Mr Chairman, I want to inquire of the Minister for an explanation as to why it is that we are, without any select committee involvement, with only less than a day's notice to members of Parliament, being asked to remove the Kiwi share obligation for telecom. Mr Speaker, the two most important utilities to everyone in New Zealand, or just about everyone in New Zealand, I suppose there's three, if we take water, it's really important that we have water, it's really important that we have electricity, and increasingly in society it's really important that in the utilities that come to us in our home and our businesses, we have telecommunications utility. Any legislation which impacts substantially on one of those utilities ought to have the benefit of full scrutiny by members of the public, by industry participants who are affected by it, by consumer groups, by industries who are affected by it. And I am very disappointed that yet again we have the government deciding that it knows best, that without recourse to the normal protections that we have in New Zealand, we are, by supplementary order paper in the committee stage of this legislation, without any prior notice to political parties or the industry, we've got fundamental changes being made to, in this case, our telecommunications laws relating to the Kiwi share obligation. Mr Chairman, we don't know what the detailed implications are of that for our country. We are kept ignorant of that fact by the poor process that the Minister has run, and this is indicative of what is now common practice, not just from this Minister, but most commonly from this Minister, but also from other ministers in the national government who abuse the processes of this Parliament. Mr Chairman, this country, New Zealand, is rare in Western democracies in that we only have a unicameral Parliament. We have one House. We don't have an upper house to provide protections against mistakes that are made in this House. We further have the entrenchment of power in New Zealand because we don't have state governments like most larger countries have, who take responsibility for significant parts of the governance of their countries, whether it's the United States or Australia. Bigger countries have state governments as well as parliaments that normally have more than one level. In New Zealand, we are totally reliant on this one Parliament, this one House of Representatives. As a consequence, we have in New Zealand built into our constitutional protections select committee procedures. Those select committee procedures are very important so that we can tease out the consequences of important changes made by legislation. And that is why, Mr Chairman, that is why it is unusual for this Parliament to be considering by amendment, by supplementary order paper in select committee, a change of this significance. Now, we have been contacted today in the Labour Party by some of the major telecommunication players in New Zealand other than Telecom, who were saying, hey, were you guys aware that this document that's just been dropped in Parliament includes changes to the Kiwi share obligation? Well, until they told me, I wasn't aware of that. This isn't central to my responsibilities. I don't have the right, every minute of the day to drop into the Bill's office and check every half hour as to whether there's another dirty trick being played by the Minister outside of normal processes. So I didn't learn about this until whilst I was sitting in select committee this morning on estimates hearings. I was tied up till 1 o'clock this afternoon then, and indeed between 1 o'clock and 2 o'clock, most of that time I was actually preparing for question time because I had question time. So I'm not the most expert in this area. I readily acknowledge that. People like David Cunliffe and Claire Curran in my party are more expert. What part can David Cunliffe take in this debate today? None. Because on this occasion he is away today on leave, pre-arranged appointment, so we on this side of the House cannot properly inquire into what are the effects of the removal of the Kiwi share obligation. And that is not good enough, Mr Chairman. And I want to know from the Minister why he thinks that is justified, that he can drop in this committee stage, why he can, Mr Chairman...
The Honourable David Parker.
I want to hear from the Minister why he thinks he is justified making this change, and to hear from him in detail as to what is the implication of this change, because the explanatory note deals with it in 2 sentences. It says, the main effect of the supplementary order paper is, and it lists some other things, and I'm only dealing with the Kiwi share applications, that makes changes to the provisions relating to deemed TSO instruments and removes references to the Kiwi share obligation. These amendments are to reflect that the Kiwi share obligation will not be operative following the structural separation of Telecom. Doesn't tell us what the effect of that is in practice. Doesn't tell us what the effect of the Kiwi share obligation is now, but will not be after this legislation is passed. Doesn't tell us what the implication is for consumers, whether they're residential consumers, whether they're businesses, whether they're competitors of Telecom. It does not tell us what the obligation. Now, for example, Minister, do these Kiwi share obligations include obligations on the dominant Telecom to treat its competitors fairly, or do we find all of those provisions in the Commerce Act? I don't know the answer to that. It's a fair question for me to ask. If the Minister shakes his head, I don't know whether he's going to tell us or not, but I would like the benefit of not just the Minister's advice on that. I'd actually like the benefit of advice from competitors in the industry to say whether the Minister is being fulsome in his explanations, or whether the Minister might be making a mistake. The Minister might have the best intentions of the world, but ministers make mistakes. We see that so often. Indeed, this very changes that are being made to this legislation late in the piece are perhaps reflective of the fact that he's made earlier mistakes in this process. So why should we in this Parliament trust that there are not other mistakes being made? Now, I've heard Mr Finlayson, the Attorney-General under the current government, get on his high horse and criticise prior governments for poor process in making legislation, because legislation made in haste too often leads to consequences that haven't been properly thought through by this Parliament. Now, given that this infrastructure area is one of the most important areas of infrastructure that we need in New Zealand, not just for businesses but also for individuals and rural customers, rural farming customers, residential people in towns and cities and businesses, I would have thought that we should be properly considering what the effect is of abolition of the Kiwi share obligation, remembering that that Kiwi share obligation was seen as a really important, fundamental part of the protections for consumers, the protection for New Zealanders that we were to have following Telecom being privatised when it was privatised some time ago. So, that has been, I thought, a fundamental part of the protection of consumer interests since, and here we are at this late stage in the process with a one-sentence explanation in this bill. We're abolishing it. Mr Chairman, I would like an explanation, a detailed explanation from the Minister as to the effect. I'm absolutely aghast that we haven't, as members of Parliament, been provided with any report as to what is the effect of it. We don't have the opportunity of asking the departmental officials for advice as we would through Select Committee. We don't have the opportunity for asking submitters. We don't have the opportunity to go to the Parliamentary Library and ask questions that we want to research ourselves, because we have a mere matter of hours to come to terms with it. So, Mr Chairman, we are completely reliant upon the disclosures that are made by the government as a consequence of this poor process that is being followed. And, Mr Chairman, that makes me very uncomfortable. And I think, given that we are a unicameral institution with no other checks and balances upon the way in which we conduct ourselves in this Parliament, I think that critics outside of this place would be rightly concerned that this is poor process, and that we will not, by the time that this voting is called upon on this legislation be able to get to the bottom of it. Mr. Speaker, Mr. Chairman, we will be voting against this bill because we don't know what the effects of it are. We don't know what the effects of it are. The Minister may not even properly understand the effects of it, and we don't get the opportunity at Select Committee to assess what the true position is.
Mr. Chairman.